in the matter of the marriage of Sherry Moser and Nicholas Moser, case number 22 DM. Petitioner Sherry Moser appears in person pro se. Respondent Nicholas Moser appears in person pro se. Attorney Leah Sorette appears on behalf of DCF Child Support Enforcement. We've been having this case set out a number of times in order to get a child support worksheet done. It looks like that has been accomplished. I was looking back through the file, and I know the parties had filed a proposed parenting plan that's never been reduced to an order. Are you all still operating under that proposed parenting plan?
Which one do you currently have?
Oh, it's the one you all agreed to and filed back on May the 8th of 2024.
Yes.
Your Honor, I do not have a copy of that parenting plan, and if you could announce that agreement or arrangement just to ensure that the child support worksheet was calculated accurately.
Okay, it was filed as a proposed parenting plan back on May 8th, 2024. It looks like the arrangement is beginning March 31st, 2024. Respondent shall have uninterrupted parenting time every other Sunday from noon to 5 p.m. The plan shall remain in effect during the remainder of the 2023 school year and continue every school year going forward. Beginning May 24th, 2024, respondent shall have parenting time every other Friday from 6 p.m. Friday until 6 p.m. Sunday. This plan shall begin at the end of every school year going forward. Petitioner shall have parenting time from 6 p.m. Sunday until the following Sunday at 6 p.m. Respondent shall also have 7 days of uninterrupted parenting time in writing to the petitioner in advance. Then there's some holiday parenting time provisions and so forth.
Thank you, Judge. From that arrangement, it does not appear as though Mr. Moser would be eligible for a parenting time adjustment.
Okay. So the child support worksheet that's been submitted has Mr. Moser paying $952 a month. Really, the last thing that needs to be accomplished under the current status of the case is to have this parenting plan be an order of the court. As of now, it's just a filed proposed parenting plan. It doesn't have my signature on it. So if you all are wanting that to be the court's order, that there needs to be an order adopting that as the parenting plan. Is that what you all are wanting to do at this point?
Yes. So it needs to be signed.
Well, there needs to be an order. I mean, it could be something as simple as order adopting proposed parenting plan, something of that nature. That has to make sure it's the parenting plan that you guys are using is the one that's referenced in the order.
Yeah, it is.
Ms. Sorette, do you all do any sort of an order regarding the child support worksheet?
Yes, Your Honor, I can do an order adopting the child support worksheet, just a journal entry of support in this case, given that previously the parties were operating under a shared expense plan. But we would not be able to include language that involves parenting time unless there were an adjustment included on the child support worksheet.
That's what I was going to ask.
Hold on a second. Could you repeat what you just said?
Who, Ms. Sorette or me?
Mr. Reddy.
It was my understanding that previously the parties had some kind of a shared expense plan where there was not child support ordered in this case. And based on the new parenting arrangement, that is why child support would be necessary.
And the new parenting arrangement, that's all in there already. A shared parenting expense plan where she submits what she spends and I pay her that per our agreement. Per my signing off on the current visitation and all the things that we have decided to do. So I don't see how that's changed at all. That's the order that we had been waiting for the judge to sign. That's what brought us to this point. Otherwise, we would be in ad litem right now, paying somebody to interrogate the children on the situation.
Right.
This is my first appearance in the court in this hearing, Your Honor, in this case, I should say. And it was very unclear from the record where we were going with today's hearing, just based on the filings. It appeared that the parties previously had attorneys that likely had discussions that I was not aware of. So if there is disagreement regarding the child support worksheet, that is obviously something that I need the court to make an order regarding.
Okay, well, I think the parties had agreed to this proposed parenting plan, and I had explained in earlier hearings that we need to get this reduced to a court order, and we needed to get a child support worksheet on file. So that's where we've been.
Yeah.
Ms. Sorette, do you have on Odyssey, can you access the proposed parenting plan?
On Odyssey, the parenting plan is not viewable to attorneys or the public. So I was trying to get into eFlex to see if it was viewable. Sometimes I have difficulty with that when we haven't filed anything yet, but since I just recently filed something, I'm hoping I can get into it.
I don't have a signed copy that I could email you right this moment, but I do have a copy of it, but it wouldn't be the signed copy. So I don't know if you'd be able to view it that, or if you would need the signed copy.
We could
Your Honor,
provide
oops,
you a
sorry.
filed stamped copy if need be, Ms. Sorette.
That would be very helpful, Your Honor. Given that DCF is not technically a party in this case, whenever I don't know, when we file our entry of appearance, however the clerks assign us, sometimes we don't get access to those things that are filed under seal or that are just not viewable to the public, which appears to be the case. I can't get into this case in eFlex, although I can view it in through the public access portal with attorney privileges. That's still a document I can't view.
Angela, can you email that to Ms. Sorette?
I just did.
Are you able to view
Yep.
the original journal entry and decree of divorce?
Yes, I had viewed that previously. The child support worksheet today was calculated based on Ms. Moser having primary residential custody without any kind of shared expense plan or anything in place, Your Honor.
Okay.
Generally, shared expense plans are only adopted when there's equal parenting time, which isn't the order, what I understood to be the parenting arrangement in this case.
I think what I'll do, you'll need time to review that and discuss with the parties, I assume, what they're doing and expecting out of this. We need to have a support or a worksheet done one way or the other, but I want everybody to be on the same page and putting it together. So do you know how to get a hold of both Mr. Moser and Miss Moser?
Your Honor, I don't generally get a hold of customers since I
Okay.
don't represent them. I represent the state, and my obligation is to represent the state and to calculate a child support worksheet based on the guidelines. I have never calculated a worksheet based on a shared expense plan when there is not an equal parenting time adjustment, Your Honor. I don't believe that the guidelines provide for that without there being an order of the court that adopts such like a shared expense plan. So I would really have to do some research into that, Your Honor.
Okay.
My understanding was that we keep everything the same in, when we were in court in person, you're the judge. You said we had to have that worksheet done and that there needed to be some child support in place. So that's why this has been dragged out. I couldn't get a hold of that other entity you wanted me to get a hold of. And then, the state came in when I had to file for, assistance, because the kids are on they're on state assistance.
Okay. Have there been hearings with Judge Murphin on this case?
No, Your Honor. This has been a strange situation in which there was already this ongoing private action. I did not file a motion for modification because there is no journal entry adopting a changed parenting plan. There isn't anything that differs from the divorce decree that was originally on file. So I didn't have any reason to modify support, given that there isn't a new order, if that makes sense regarding
Okay.
parenting time.
So in your
Um,
role, do you have to have the order adopting the proposed parenting plan in order to proceed?
Usually I need something that confirms a change. In this case, I could tell that you were unwilling to proceed without a child support worksheet, which is why I went ahead and entered my appearance and filed a worksheet based on what I believed to be the party's current parenting time arrangement. So obviously, this is a proposed child support worksheet. There is obviously a provision in here for shared expense formula. If that is the direction that the court would like to proceed, I think that I'm going to have to work differently through the child support, as the Bradley calculations don't necessarily allow for shared expenses without that equal time provision.
Well, again, you all are going to have to file an order adopting this proposed plan, because as of now, it's not a court order. And if that's what you guys are operating under, you need to file an order adopting that as the parenting plan. You should be able to utilize the same forms that you've been using, or find them on the Judicial Council website, in order for that to become a court order, modifying what was the current order, which would have been from the divorce decree.
Your Honor, I filed that already.
There's
That's
nothing's been, when do you think you filed it?
that's really why we're here. The document that we're referring to would have been one that I typed up, printed up, and then the court accepted. And then Sherry and I signed it and gave it to you. And then
Right, and that's a proposed parenting plan, and I told you all a couple of different times at various hearings that needs to be adopted as the court order, because that's just a proposed parenting plan until it's adopted as a court order. So I need an order adopting this as the parenting plan. Otherwise, it's just a proposed parenting plan in the file. It's not a court order.
okay.
So how do we get that? How do we get that finished and finalized?
Well, you'll need to utilize some forms from the Judicial Council website or wherever you've been getting forms, and just attach a copy of this, or make it an order adopting the proposed parenting plan filed on May 8th, 2024.
So what do you need exactly, Judge?
I need an order adopting the proposed parenting plan as the, however you want to title it, but if you want this to be the parenting plan, it needs to be an order adopting modified parenting plan, something to that effect. And make sure you're referencing the proposed parenting plan filed on May 8th of 2024.
Here's my other question. If I decide not to do that, it reverts back to the original parenting plan. That's the one we're under. Not the one we're asking to adopt, or we're about to ask to adopt, but the original one.
Whatever the prior order was before you all were doing this.
That's what I needed to know. All right, I'll I will get this order adopting proposed parenting plan, which has specific details on everything in it already. And what do you want to do? Reschedule a court date? How do you want to go
Well,
about it?
we'll need to schedule a new court date, and then that'll give you time to get that on file, and that'll give Miss Sorette time to look that over and make any adjustments that need to be made in the worksheet. Do you need any other information, Miss Sorette?
Well, Your Honor, I'm reading through the Kansas Child Support Guidelines regarding shared expense plans, which is what's referenced in this proposed parenting plan, and I'm not sure what they've written in here meets the specifications as required by the guidelines. So I think the parties either need to consult with private counsel or need to review the Kansas Child Support Guidelines to ensure that all of the requirements are met in order for a child support worksheet to be calculated using a shared expense plan. I can't give advice in that way, Your Honor.
Understood.
Additionally, Your Honor, my last day with Young Williams will be February 19th. So if a hearing is set after that date and time, I will provide that to my replacement. But it may be that that person cannot appear on the particular date that's chosen.
Okay. I'm assuming you'll pass on appropriate notes and.
Yes, Your
whatnot.
Honor. I will, absolutely.
All right, well, let's set this out about 30 days or so. Allow this to work its way through. If you all need to consult with an attorney, you can do that.
Judge, have March 13th at 10 o'clock.
March 13th at 10 o'clock.
Is that a Monday?
Thursday.
You could do it on the next available Monday.
March 3rd at 11.
At 11 a.m., that'll work.
Does that work for you, Sherry?
Yeah, I can make it work.
All right, and Miss Sorette, you'll have that date?
Yes, Your Honor.
Okay. All right, anything further we need to do this morning? All right, if there's nothing further, we'll be in recess. The matter of the marriage of Sherry E. Moser, petitioner, and Nicholas Patrick Moser, respondent, case number 22 DM 212. The petitioner Sherry Moser does not appear. Respondent Nicholas Moser appears by phone. Brandy Ridgway appears as counsel for DCF. We were last before the court on February 3rd. At that time, both parties appeared. Miss Sorette was appearing for DCF. It was announced at that time that we just need to get the journal entry done from the March 19th hearing from last year, which was the party's parenting plan. I still don't see that an order has been filed adopting that parenting plan. Mr. Moser, have you submitted anything?
I have not. I kind of gave that to her. It doesn't really benefit me one way or the other. She has not had an opportunity to finish typing that up, which is, I believe, what she said she was going to email you today, and would ask for another 30 days to get that in order.
Miss Ridgway, it's my understanding, at least from the docket notes, that Miss Sorette was going to journalize the child support obligation, but perhaps was needing the journal entry adopting the parenting plan to be able to do so.
Yes, Your Honor. Right now, the court-ordered parenting plan is for 50-50 shared custody with shared expenses. The proposed parenting plan gives the mother sole custody and allows the father, I think, every other weekend parenting time, with in the holidays is divided out. But based on the existing order, child support, would be shared, or I'm sorry, would be on a shared plan. And that's not what the parties seem to be exercising right now.
Well, the issue being, and I know DCF came into this after that had already been done, but it was announced on the record back in March 19th. We just don't have the journal entry from that
Okay.
done yet. So I think what I'm going to do at this point is we need to get this matter wrapped up. I'm just going to prepare an order adopting that proposed parenting plan that's in the file, and I'll do that myself.
Well,
So
according to my child support calculations, child support would be $952 a month. Based on that, I know the proposed parenting plan is that they share expenses, but since they are not sharing custody or sharing parenting time on an equal basis, the shared expense plan does not apply. It would be calculated based on the mother having residential custody. And the DCF's concern is that the parties' income combined is over $93,000 a year, but with their proposed plan of no child support, the taxpayers are footing the bill for the children's food stamps.
okay. All right, Mr. Moser, anything you would add?
Yeah, I don't understand how they're even qualifying for food stamps. I'd say the DCF needs to drop the case.
Well, the problem is right now it's based solely on the mother's income with no child support being ordered, because that's what the current court order is.
Anything else, Mr. Moser? All right, well, I'm gonna prepare the order adopting the March 19th agreement, which is the proposed parenting plan that was filed with the court on May 8th, 2024. And just so that'll put a bow on that piece of it. And then Ms. Ridgway, any recalculation that needs to be done can be submitted. And then if the parties want to litigate that further after that's all been done, then that'll be up to them to submit whatever appropriate motions.
Okay, Your Honor.
Your Honor, I don't fully understand what that means.
It means we've been waiting since March 19th of 2024 to have an order, a journal entry adopting what you all agreed to. And since that hasn't been done by either you or Ms. Moser, I'm going to file the order adopting that so it can be done. And then the child support is what it is based on what you all have agreed upon as far as the parenting plan. And DCF is going to submit that order.
Does that mean that it changes from what we agreed upon?
I'm not sure how it will shake out in the end.
From DCF's point of view, Mr. Moser, yes, it will change. The law doesn't allow you to agree to a shared expense plan. So we'll be calculating child support based on the custody that you're actually exercising.
Then I would want to withdraw any of the proposed plan at all figured on March 19th. And I would say the plan is now 50-50 custody. The reason that we did this was because my parenting powers were taken away by the court themselves. And in order to get any parenting time, I had to get her to agree to a plan, which I did, at which point she basically quit paying her lawyer. Now, out of good faith, I'm willing to stick with the plan, but if it's changing, then no, I think it should be 50-50 custody. During this time, she moved the kids out of the town, to a different school. It put me in a position that the only way I could exercise my parenting powers was to pull the kids out of school for a third time and force my will that way.
So in order to keep the peace, okay, I invented a way that was conducive to what I believe would be best for everybody. As far as food stamps and all that, I wouldn't even know how she'd qualify for any of that stuff. She makes as much money as I do. So I really think that there's whatever is going on with the SRS. I don't quite understand any of that. But at this point, no, I would not want this order to continue. I'd
Well,
go back
it
to
is what the court ordered. It was just never journalized. So I'm going to prepare the order adopting it. Then if you want to file a motion to modify that order, then that's something you can do, Mr. Moser. It's just basically housekeeping, cleaning up what's already been ordered that's never been journalized and placed in the court file.
Okay. I mean, there's nothing I can. I mean, if that's what you're going to do, then there's nothing I can do about it.
I'm not going to set an additional hearing at this point. I'll get that order done and filed, and then Ms. Ridgway, if that gives you the information you need to file whatever you need to, then you can just go ahead and do that.
Yes, Your Honor, I'll file another motion and set it for a hearing on Judge Murphin's docket.
Okay. All right. If there's nothing further, we'll be in recess. Thank you, everyone.
Thank you, Judge.